Oh my God. Already? Kick me out. I ain't said nothing yet.
How are you?
Fine, how are you?
All right, we're on time, please.
Behave yourself. I am.
Good to see you.
I can't shut it off. We'll call the meeting to order. This is City Commission meeting, Monday, March 25th, 2024. It's 5:30 p.m. Would you please rise for the invocation and the pledge? Heavenly Father, we ask that you watch over this group tonight, that you give us the wisdom to make good decisions for the city of Leesburg. We do this in your name. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Have a good crowd here tonight. Just a couple of announcements. We are going to have a first reading of the Sunnyside property tonight, the PUD, at which time we're going to have Dan come up and explain that PUD to us. We are not going to have any public comment for that reading tonight, okay? But later on in the meeting, There will be a discussion of the magistrate's rendering, and at that point, we will have public comment. So we will be able to talk about it. We just don't want to talk about it twice. Okay? All right, so item 2 is proclamations. We have none. Item 3 is presentations. We have none. Item 4 is public comments. This section is reserved for members of the public to bring up matters of concern or opportunities for praise. Issues brought up will not be discussed in detail at this meeting. Issues will either be referred to the proper staff or will be scheduled for consideration at a future City Commission meeting. Comments are limited to 3 minutes. Would you please give your name and your address when you come to the dais? Any comments?
Good evening, Dr. Erica Jasper, 2110 Johns Avenue, Leesburg, Florida. I'm here just to bring public awareness to our annual spring cleanup on April the 6th on a Saturday. We'll be at Berry Park, J.L. Johnson Park, Susan Street Park as well. So we're soliciting all volunteers and anyone that need any community service hours during this time. So thank you.
Any other public comment?
Murray Tucker, Lone Oak Cemetery Board of Trustees. I'm sorry I'm a little late for this, but my schedule's been a little bit hectic. But the rest of the board and I would just like to thank the city of Leesburg for their participation in Sergeant Hall's funeral at Lone Oak a while back. All the agencies just did phenomenal. So many of the commissioners showed up. Just that flag when you pulled in under that fire truck was just breathtaking. This was an absolutely once-in-a-lifetime event, and I think you all made the city look really, really good. So on behalf of the board, thank you for all that, and the city ought to be very proud.
Thank you, Murray. Any other public comment? Move now to the consent agenda. Item 5, routine items are placed on the consent agenda to expedite the meeting. If the commission or staff wish to discuss any item, the procedure is as follows. 1, pull the item or items from the consent agenda. 2, vote on remaining items with 1 roll call vote. 3, discuss each pulled item and vote by roll call. Are there any items anyone would like to pull? All right, could I get a motion to approve the consent agenda?
Make a motion to approve all items on the consent agenda.
Second. Roll call.
Commissioner Connell?
Yes.
Commissioner Reisman?
Yes.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Mayor Burry?
Yes. We'll move on to public hearings and non-routine items. Second reading of ordinances, we have none. We'll go to 6B1, which is first reading of ordinances. Would someone please introduce 6B1?
I'll introduce and ask to be read by title only.
An ordinance of the City of Leesburg, Florida, in accordance with the special magistrate's recommendation pursuant to the Sunnyside Lake Landing Holding, LLC, and Cenizo Ventures Florida, LLC, versus City of Leesburg, dated January 15th, 2024, rezoning approximately 120.5 plus minus acres from PUD to PUD planned unit development to allow for 150 detached single-family residential dwelling units on a property located south of U.S. Highway 441 and west of Sunnyside Drive, as legally described in Sections 29 and 32, Township 19 South, Range 25 East, Lake County, Florida, and providing an effective date.
This is a first reading, so Dan, would you please come up and give us a little information?
And Mr. Mayor, if I may, I'll go ahead and get everybody sworn in for the ordinances and non-routine items before Mr. Miller gets started.
Sure.
All right, everybody in the audience, including city staff, you would please stand and raise your right hand if you plan to provide any testimony on any of the ordinances or non-routine items resolution this evening. Yeah. Please stand and raise your right hand. Now is your time to be sworn in to speak tonight. All right, nobody else plans to speak this evening? Okay. Do you swear or affirm that all testimony you'll give tonight will be the truth, the whole truth, and nothing but the truth? I do. All right, thank you all.
Thank you, Dan.
Thank you, Mr. Mayor. Dan Miller, Planning and Zoning. This is the first reading for the PUD as recommended by the magistrate. This is a request for an ordinance to rezone approximately 120 acres, which is generally located south of U.S. Highway 441, west of Sunnyside Drive. The project, as it sits, now contains 150 units on 120 acres for a gross density of 1.25 units per acre. Again, you will recall this is proposed PUD as the result of the special magistrate's recommendation of settlement, which is also on tonight's agenda under item 6C1. This PUD differs from the PUD application submitted to the city originally in the following areas. Number one, the total acreage on the project has been lowered from 139 acres to 120 acres. This is due to the land to the east of Sunnyside Drive has been dropped from the plan. The total number of units under consideration was reduced from 159 units to 150 units. And then dropping the total number of units did increase the size of a few of the open space buffer areas, meaning adjacent to the nearest properties with existing residences. I don't have those exact numbers, but increased it a little bit. All other requirements of the PUD as was previously presented have been maintained. That includes the requirement for 50, 70, and 80-foot lots, design and architectural standards for the houses, the 25-foot planted buffers around the perimeter of the property. There's also the requirement for the boulevard entrance, sidewalks, and upgrading the roadway adjacent to the property, as well as preservation of the wetlands and recreational requirements that remain as well. Thank you, Mr. Mayor.
Any questions for Dan? All right. As this is a first reading, it will come back to us on April the 8th for the second reading.
Yes, sir.
And the public hearing, yes. Okay, so would someone please introduce 6B2?
I'll introduce 6B2 to be read by title only.
An ordinance of the City of Leesburg, Florida, adding a PDO, Planned Development Overlay, with a waiver from Section 25-282, parentheses A, parentheses 1, PDO 5-acre minimum, to the existing R3 high-density residential zoning on approximately 0.22 plus minus acres to allow for an office, retail, and classroom uses for property generally located south of East Main Street and west of Mike Street, lying in Section 25, Township 19 South, Range 24 East, Lake County, Florida, and providing an effective date.
Thank you, Andy.
Yes, sir.
Dan, would you?
Thank you, sir. This is first reading for this CDC Mike Street Office Plan Development Overlay. It's a request from the Community Development Corporation for a plan development overlay to allow for office, retail, and classroom uses. The property is generally located on 0.22 acres on the west side of Mike Street and south of Main Street. It's about halfway down Mike Street from East Main on the right side. The lot goes all the way through from Mike Street over to Child Street, so it makes it a double frontage lot. Just some background, PDOs, plan development overlays, are similar to PUDs, but are simply an overlay to add for additional uses or conditions for or design for uses not found in the underlying zoning district. In this case, this is very similar to the one that was done down on the corner right here, PDO done there for CDC for the same thing. Property is zoned R3 high-density residential, and the proposed uses are office, retail, and classrooms. And this is the, looking for Pastor Christian. Thank you, sir. This is the office, former office of James Durden, who was one of the first, or I believe the first African-American attorney in the city. Thank you, sir.
Just a question for you, Dan. On the overlap, it seems that there's a house that's kind of on both sides of the line.
The only way to determine that for 100% is to have a specific survey, a new survey done. We find this happens quite a bit when you scale the maps in and out, and sometimes it looks like it's a little bit over and it's not. In this case, I couldn't guarantee that it is or is not, but we do find that scaling the maps in and out makes it a little difficult.
And what's the plan for the house?
The building will stay. They're not planning to do anything other than renovate the building. It's kind of a historically significant building for sure.
I have a question.
For Dan?
Yes, I have a question. So the original building that we're seeing, that's the original attorney's office, correct?
Yes,
So
ma'am.
we'll be extending beyond that?
At this time, there's no plans to extend the building. They could potentially in the future. Right now, what they just want to do is refurbish the building and make it into some additional uses for the office, retail, classrooms for CDC.
So is there any way possible I could request more information for the actual Pine Street project in itself as a whole? I understand that this is the second overlay.
Yes, ma'am.
Okay, will we be anticipating more going forward?
It depends. It's really a very individualized situation. A PUD generally encompasses, a planned unit development generally encompasses a larger area and includes all of the zoning for that area. A PDO is just an overlay to add to something to that area to make it more useful.
And could it be changed again later on?
Any of these
Possibly. That's
zonings,
what-
yes, ma'am,
that's
could
what I'm
be.
thinking.
That's
Okay.
correct.
Thank you.
Does anyone have questions for the petitioner?
Yes, I would like to add, please. Pastor Christian, good evening. I just want to make sure that I'm understanding, and if any way possible, I can get further information to be clear with understanding so that when the PDOs come up and available, I can be, my vote could be true to what's going on. I know I've been invited to a meeting in which I plan to attend, and I'm hoping that I could get all information so that I can know each time a PDO is coming up or planning on what the actual goals are set for short-term and long-term for the Pine Street project.
Yes, ma'am. And this is John Christian, 903 County Road 468, Leesburg, Florida. The reason to ask for the PDO is this building is actually active. We've had people renting the building. My newest tenant, she's actually involved with the state of Florida with Medicare, and they needed an office. Although it was an attorney office, it's zoned residential. As you would, unfortunately, in this neighborhood, we found that although many of these buildings were used for commercial zoning, commercial uses, they have residential zoning. So that is the reason for the PDO. This building in particular has already been remodeled. It's already been actively used by several tenants. They just didn't need state approval. The newest tenant needed state approval, needed zoning for commercial, and that's why we had to engage with the city to get that zoning. So if we didn't need state approval, we probably wouldn't be here asking for a PDO, but unfortunately, although it's Mr. Durden's law office, it was zoned residential. So that's kind of why. And we'll do an update and we'll give to the commission on the plans, because we have several businesses that are there, and we'll give a proper introduction to all the businesses on Pine Street to the city commission so everyone can have that plans of the CDC. Thank you, Mr. Mayor and Commission. Appreciate your consideration.
Any other questions? No. Grant, do we need public comment on this?
You can ask for public comment in case anybody has any.
Is there any public comment on this project? All right. Any other commission comments? All right. This will lay over and be heard again on April the 8th. Someone please introduce item 3, please.
Introduced and asked to be read by title only.
An ordinance of the City of Leesburg, Florida, amending the City Code of Ordinances, amending Article 4, Chapter 9, Elections, providing for 5 single-member commissioner districts, providing for severability, providing for conflicts, and providing an effective date.
Comments? Grant, maybe you could just kind of give the public a reason for this.
Yes, sir. I'll be happy to do that. So basically, this is sort of a house cleaning type ordinance here. When the charter was amended to account for districts 4 and 5 no longer being floating seats, the city code was not updated. So really, this is just to make sure that the city code is consistent with the charter amendment. The charter amendment would govern anyways, but really just to make sure the code and the charter are all consistent with one another.
Thank you, Grant.
Yes, sir.
Any public comment on that? All right. This again will lay over until April the 8th. Would someone please introduce item 4?
And asked to be read by title only.
An ordinance of the City of Leesburg, Florida, amending the boundary lines of the Village Community Development District Number 14 pursuant to Chapter 190 Florida statutes and providing an effective date.
Comment? Any public comment on this? Dan, do you want to give us an overview?
Thank you, Mr. Mayor. This is a request for an amendment to the overall boundaries of the area, which encompasses Community Development District number 14 within the villages of Westlake. I think everyone's pretty familiar with CDDs by now. They are provided under Chapter 190 Florida statutes as a method of creating and funding special purpose districts to manage, finance, and deliver basic community services such as water, wastewater, roads, bridges, security, etc. There are limited to specific areas and cannot encumber debt to the local governments and have no zoning or police powers. In Exhibit 1, basically what they're doing here is they would like to amend these acreage is to eliminate 1,372 acres out of the current 2,385 acres. So you'll end up with a district of 1,013 acres. That 1,013 acres basically consists of the area of 470. Can you come down a little bit, Anna, please? I'm sorry, the other down. Thank you. So they want to keep the, is that Exhibit 1? Okay. They want to keep the 470 area in here as that's where the houses are currently constructed. The remainder of that, if we go to the next exhibit, please. I think there's an Exhibit 2 and 3 following that. There we go. So this will be the area that they're keeping. This area over here is what they want to get rid of, which is south of 470 and north of the Turnpike, and then down here in the old Renaissance Trails area. So those are the areas they want to eliminate. This is the area that was proposed at this point for the people who work in the villages but are not 55 years old. So they'll eventually get their own CDDs, we anticipate, at this time. Beyond that, the city has about 6 or 7 other CDDs in, and we anticipate a number more coming as the city develops over time. Thank you.
Any questions for Dan? Any public comment? All right. This will, actually, we don't have a date for this in May, but yeah, we may have to submit for, yeah. Okay, so we don't have a date certain for you, but we believe at one of the 2 meetings in May will be a second reading on this. At this point, will somebody please introduce item 6C1?
6C1 to be read by title only.
Resolution of the City Commission of the City of Leesburg, Florida, accepting the settlement agreement with Sunnyside Lake Landing Holding, LLC, and Cenizo Ventures, LLC, and providing an effective date.
So, Al, you want to give us just a quick
brief staff report on that. The city of Leesburg has been considering the Sunnyside Lake land holding situation now for a couple of years. Let me just recap where we're at and the purpose of the resolution this evening. Just to summarize, essentially the City Commission turned down the petition to rezone and land use this property. The units and acreages and uses were all outlined by Dan earlier under the PUD, which was on first reading just moments ago. The city annexed some of these properties, but then we did not move forward with zoning and land use of these areas. When we did, the city, by basically a 2-2 vote, did not grant the requested land uses, which were similar to what Dan outlined. And that triggered filing a petition, I believe it was a writ of certiorari against the city, which is asking the court to provide a legal interpretation on the actions that the city took, which was to deny the request for a PUD. The vote was 2-2, which is a denial. A vote of that case would require a majority vote of the commission, which would be 3. So even though it was a tie vote, it is by all means considered a denial. When filing a petition against a municipal corporation, there's a steps are outlined in statutes on how that proceeds, and it's essentially for ease of delivery a three-step process. A mediator is required to be hired. Both sides picked a mediator. Both sides agreed, and we picked a land use attorney who's done several cases before, and he was an experienced land use attorney by the name of Carlos Alvarez, and he served as our special magistrate. We then commenced the first step, which was a mediation. At the mediation, both sides met. The commission, prior to that mediation and subsequent to, don't hold me to the exact number, I think you had 2 or 3 shade meetings, maybe 4, all posted correctly. All records were kept. All records of all of the shade meetings will be made public when the matter is settled. So everything that was discussed, reviewed, and considered will become a matter of the public record at settlement time. So based on mediation, I'll summarize it very succinctly. There was no movement by either sides, with direction from the commission to enforce the Sunnyside land development resolution, or the formal name of the Sunnyside Accords, if you will, which was developed in the early 2000s, laid out a series of lessening densities from 441 south to the tip of Sunnyside, where the tip of Sunnyside would be I believe it was 1 to 3 units per acre. It was the commission's decision that this development infringed upon that task force recommendation. So essentially, the rough numbers were, at that time, I believe the petitioner wanted a PUD approved for about 159 units, and the city commission wanted to see a development in the neighborhood of 40 or 30 lots. So obviously, a big disparity. The mediation actually was very short. I think we met that morning for about 3 hours. With the distance in the sides, there was really looked like there was no reasonable way to solve this issue, so we moved into step 2. Step 2 of the specified process is to have a rehearing of the case, and the hearing was conducted by the city, by the special magistrate, who served as the quasi-judicial parliamentarian, if you would, of the proceedings. And both sides, the city represented by Briones and Briones, and the petitioner side represented by Mr. Spain, made their cases to the special magistrate. Each side was then requested, based on the testimony heard by Mr. Alvarez, to provide a recommended order. Our recommended order was to ensure that the Sunnyside Accords, if you will, were approved and implemented, and the petitioner side was to approve the PUD. In short, the special magistrate's recommendation came back in January. It's been made part of this proceedings this evening. The special magistrate's report was made public. It is in the agenda package in 2 locations. It was under the first reading of the ordinance adopting the PUD, and it is also made part of this resolution. Essentially, and in short, there was the 40-page recommendation, but essentially Mr. Alvarez completely ruled in favor of the petitioner. Let me repeat that. Mr. Alvarez's recommendation was completely in favor of the petitioner, not yielding 1 iota of the city's argument. With that, we held another shade meeting, and it was a consensus and direction of the commission that it was probably now in the best interests of the city to consider a settlement agreement. After that shade meeting, we instructed our attorneys, Briones and Briones, to go to Mr. Spain and work out a settlement agreement. At this stage, there's a third phase of this dispute, which I will describe, but there's really 2 now phases left, or 2 options left for the city. One is to approve the settlement agreement, which is before you tonight. That settlement agreement ends the dispute and it agrees to implement the order that's recommended by the special magistrate, which is the PUD that Dan spoke to this evening on first reading. Should you approve the resolution that ends the settlement, you will then have one more step, which is to approve the PUD. I think it's important to point out tonight that even though the PUD was heard on first reading, that is not approval of the PUD. That is first reading of an ordinance. That's the process to adopt a PUD by ordinance. The final product of the PUD would then be heard on April 8th, where public hearings will be conducted and the public will have opportunity to speak. Let me sidetrack a little bit here just for procedural information. It was determined by all attorneys involved that starting the PUD from inception, which would be the petitioner petitions the Planning and Zoning Department with the proper city application forms. Those are processed by staff. Those go before the Planning and Zoning Board. Then that comes before the City Commission in 2 readings, 1 reading of which we would take a break and issue the recommendations to the state because it's a large-scale modification, and then back to the state. All of that we determined is not necessary. It is not necessary because the petitioner went through this all before, so therefore repeating the process is not required statutorily. It was the ruling by our attorneys. So you are left with the process of, if you settle, you then have to approve a PUD. If you do not settle, you then would go to the 3rd phase of the process, which would be to hear the writ of certiorari before the circuit court. Excuse me. That is an option to you. Our staff recommendation to you this evening is to settle the matter based on the special magistrate's report. I think it's important to point out that part of the writ of certiorari kept all costs associated with the litigation and the matter to each side. So in English, that means the petitioner pays for their attorneys and we pay for our attorneys. I think that's an important consideration, and I also think the recommendation and the information that was provided in the special magistrate's report is very important. So for that, that would conclude the staff proposal and our recommendation, which is to settle the matter and move forward with adoption of the PUD on April 8th.
For clarification, can you give the dates of the different hearings?
No, but I can get that to you. If you need a chronology of that, that can be provided.
At this time, I think before we have discussion among the commissioners, let's allow for public comment on this. So those that want to make public comment, please come.
I'm a bit confused. The PUDs have a second reading. I was under the impression that the settlement, this was first reading, the settlement would not happen until a second reading. Am I incorrect about that? Because our team was going to defer until the next reading.
Yes, you're incorrect about that. The process is 2-phased. You have to approve a settlement agreement, and pending which way you go in that process would require the adoption of a PUD. Since the settlement agreement issues the petitioner their planned unit development, you then would have to approve a PUD. If, for example, we would not have, if the recommended order per se, let's say as an example, would have been in the city's favor, and the petitioner would not have, the petitioner may not have wanted to move forward with their PUD, then you did not have the PUD issue to deal with. So one way or another, the city will have to deal with the PUD if it's determined that the city, in turning down the PUD, was incorrect. So whether we settled the matter and have the recommended order, which says, if this body agrees with the recommended order, you have to do a PUD. If we go back to court, I will assume the same as well. A PUD or a court order would then be issued to the city that would adopt the PUD. So a PUD has to be adopted in some sort of fashion. The process really isn't germane on, which comes first, the chicken or the egg. The PUD is adopted by ordinance. 2 readings of the ordinance have been set up. Now the second reading potentially for April 8th. And the settlement matter by resolution, because the settlement is an agreement, not a PUD. We adopt agreements by resolution.
Okay.
All the PUDs, this agreement, have all been duly advertised.
I understand, just not the way it was presented to me. Had I known that, we would have had a full team here. I don't know that I agree with how this is going to go down, because our team's not going to have a chance to present. So
we would move for a continuance. Considering that we got the notice was only sent out on March 12th, and I believe your testimony was you had the agreement. I'm Dave Coffin. That you had the agreement back in January, and as a party to the application or applying the Sunnyside agreement, we should have gotten notice of it. We did not get notice. And in fact, one of your commissioners didn't get notice until last Friday, I believe. So we would ask for additional time. This has gone on for years. And now to take a position that may prejudice us because of a notice that went out March 12th, and I think a number of people did not even get the notice who lived within the guidelines. So we would ask that occur and submit that, because it has taken years and years for y'all to get to this point, it would not prejudice the city.
Right, Mr. Cawthorn, I respect your legal opinion. At the end of the day, the commission knew about the proceedings. The public, I think, knew about the proceedings. Our resolution to adopt a settlement agreement was publicly advertised and duly followed the correct process. It would be up to this body if they want to continue it. There are some time parameters associated with the continuance that the petitioner would probably have to agree to. Our counsel is in the back nodding at what I'm saying. So I would just advise you that if you think that that's grounds for action in the future, I would respect your opinion.
Sir, as an additional point, can you tell me who the applicants are?
The applicant is Sunnyside Land Holdings, Sunnyside Lake Land Holding LLC, and Cenizo Ventures LLC, represented by Mr. Brent Spain.
Okay, and I would point out that Cenizo Ventures is not a valid Florida corporation. It was lapsed, and so you can't proceed because of the lapse in the corporate entity. It was dissolved.
Duly noted.
Okay.
Mark Briones for the record.
So with that information, as our attorney on this item, do we need to pause?
No, I think you have everything that you need in front of you. As a matter of fact, the special magistrate's order had a certain time period in which this commission would have to act. The petitioner did agree to extend that time period to today, and so that's why you have the settlement agreement in front of you today.
For what it's worth, here it shows the corporation is dissolved and it was lapsed. Then you're asking the commission to vote on it today?
That's correct. That's pursuant to the magistrate's order. Unless the petitioner again agrees to extend the time period which they are here. I'm not sure if he wants to speak or not, but he is here.
Good evening. For the record, Brent Spain, Theriac and Spain, 1809 Edgewater Drive, Orlando, Florida, on behalf of the petitioners in this matter before you this evening. I'll just briefly, one, on the Division of Corporations information that's been handed out. The entity is actually a Delaware corporation, so that's why the information from Florida SunBiz is not accurate. That's actually a different entity than is the property owner of the subject site. So that was actually corrected in the settlement agreement that's attached. And you'll actually see when my client signed it, they actually write through the Florida Limited Liability Company, and they hand initial it that it's a Delaware Limited Liability, or actually a Texas, my bad, Texas Limited Liability Company. So that's why the information that the gentleman handed out is not accurate. With respect to continuing it, at the end of the day, that's a matter within your all's discretion and purview. I would say this, that I don't think anybody in this room is surprised that the matter is on the agenda this evening. It's been covered by the local newspaper. Mr. Tucker attended the special magistrate hearing. I'm sure he's been actively following the matter with the city, either through email communications or public records requests. So I'm a bit surprised by the suggestion that somehow they're prejudiced by this. As a land use attorney with 24 years of practice, that seems like trying to put an argument on the record so they can potentially challenge it down the line and say, oh, look, we were prejudiced. You know, the reality is they're going to have a full and fair opportunity to present at the second hearing. Which on that point, this is the first time I've heard that it was scheduled for April 8th. So I would like to go on the record. I'm actually in Massachusetts on April 8th looking at a school for my child, for my son. So I'd actually ask that that second reading be on April 22nd, which I think is the following meeting, which certainly would provide the individuals an additional 2 weeks to be prepared in advance of that second and final reading. With that said, I don't want to belabor things that the city manager indicated. I do want to clarify a few things so the record's clear. The annex, because a few of the commissioners were not on the board in March of 2022 when this matter was denied 2-2, which is a technical denial. There were only 4 members present. The annexation was denied. The annexation involved the 18.5 acres on the east side of Sunnyside Drive. The future land use was also denied for that 18.5 acres. So that reverted the PD proposal back in March of 2022 to the original parent tract, which is the 120-acre parcel that the city had annexed in 2005. They'd actually rezoned it to PUD in 2005, and they assigned a future land use to the 120 acres in 2006 of estate residential. We're not here before you this evening on any comprehensive plan amendment. There's no annexation. There's no land use change. It's simply, as already has occurred, a first reading on a proposed modified PUD, and then the proposed resolution approving this settlement agreement before you, which, as the city manager indicated, this settlement agreement's purpose is to implement the special magistrate's recommendation, which followed an all-day evidentiary hearing. So unlike the hearings you all see in this, I think Commissioner Burry or Mayor Burry attended the magistrate hearing, but there was full cross-examination of the witnesses. You can introduce evidence. It's very much like a mini trial. It's more formal than your regular zoning hearing. It went all day. There was a 40-page order entered as the city manager indicated, in favor of my client on all the issues that were raised. And the magistrate had recommended approval of a modified plan. And in that modified plan, as touched upon, my client had reduced the number of total units. We increased the buffers and open space near the closest residential units. And we intend to do a full presentation at the second reading so that the record is clear. But the main issue, which clearly was the main issue 2 years ago, I was counsel 2 years ago, was the applicability of the Sunnyside Task Report. And I don't want to bore you with details in the magistrate's order, but he did not just gloss over that issue. He thoroughly considered that issue, and he explained in detail his reasons for rejecting that, both from a factual standpoint of the history of this property and from a legal standpoint, that task study was never implemented in the city's comprehensive plan and land development code. And in fact, I think the one part I did want to quote was, and I'm quoting from page 6 of his order, quote, "There is no land use regulation in Florida and likely in any state that is enforceable or valid under such circumstances. Such a scenario is the definition of unreasonable and arbitrary and certainly unfairly burdens the use of the property." And he goes on in the actual body of the order to discuss why that's the case. So again, my client has been trying very diligently to be receptive to the city's concerns, the residents' concerns, and also cognizant of the land use rights that were granted back in 2005 and 2006 with the future land use on the property, the prior PUD, which the magistrate also indicates never technically expired on the property. And we would ask you respectfully for your support of the settlement agreement that comes before you this evening with staff support as well as my client's support. In fact, my client has already executed the settlement agreement. And again, at the end of the day, you'll have a second and full reading on the PUD ordinance. And Mr. Tucker and them are fully able to make a full presentation there. And in theory, if they don't like the ultimate decision, if that PD is approved on second reading, they have the right to retain counsel and try to challenge that approval in court. But the matter before you this evening is the consideration of the settlement agreement. Whether you all decide to defer the settlement agreement to the second reading, which I would ask be on April 22nd, that's a matter within your discretion. If that's the purview of this board, I'm not going to sit up here and kick and scream and object to it. Our client is just as eager as I hope the city is to resolve this matter amicably. As indicated, it's been going on actually for more than 2 years. I think I first got involved in 2019, 2020, because I recall appearing before this board with a mask, so I know it was in the middle of COVID. So again, we appreciate your support. I'm here to answer any questions about the modified PE, the site plan. I have our planner here, but again, we weren't intending to make any presentation. We have no PowerPoint. This is sort of just an administrative hurdle that needs to be crossed in order to get to the second and final reading. So.
Any questions for Mr. Spain? Hang on one second. Any questions for Mr. Spain?
Just for clarification, are you? City manager referenced there was a deadline for us to approve this. Are you granting us till April 22nd?
May 22nd.
May 22nd. April 22nd. And I'm only bring it up because we got to discuss it anyway. Just soon hear it all at one time. I don't want to hear it 2 different times, but I need your blessing on that.
Yeah, I get. So the deadline is under the statute. There, you all have 45 days to consider a recommendation from the date it's issued. So the recommendation was issued on January 15th. So to get to this date, my client had to extend it to March 25th, which we did in light of the settlement agreement that had been
Thank you for that clarification. You answered my question there.
Yeah.
I mean,
and so at the end of the day, to be more specific, if at the end of the day a majority of you says we're inclined and we prefer to defer both things to April 22nd, I'm not going to object to that. I don't think there are legal grounds raised by Mr. Tucker to do that, because he's here this evening just like I am, and I'm not doing a presentation either, and he'll have the full opportunity to do that at the second reading, but I'll leave that to you all. If you vote for that, I don't object to extending it to April 22nd.
Okay, thank you for that clarification.
Any other questions? We have another comment?
Yes, sir. We're not asking to really delay anything. We're asking that nothing be prejudicial today. And I can tell you that several calls were made to City Hall to find out what the procedure was. And it kind of reminds me of when Sunnyside Homeowners Association met with the city of Leesburg several years ago, and we entered into an agreement. It's been posted on the map for this, the county and the city. The agreement was with the city and the county and Sunnyside. And all of a sudden we learned that somebody's position is it doesn't apply to us. But the resolution is still on the books. It has not been vacated. And we just want an opportunity to come back before the board without being prejudiced by not having our whole group here today. And it's the same procedure we were told that the last time. And the last time we didn't have a big group on day one, but we did on day two. And we intend to, and we do have counsel who was not able to come today and told us don't worry about it. And there's no prejudice to the city. Thank you.
I didn't swear in, but I feel like it's relevant.
Do we need to swear? Do we need to swear?
Yeah, I think, Mark, you mind?
Do you swear or affirm that the evidence that you will give will be the truth, the whole truth, and nothing but the truth? Thank you.
My name is Wendy Barriger, and I own the 14 acres that shares an actual boundary with this. I've owned it since September of 21, and the notice that I received about this meeting was the absolute first that I have received in regards to this. When I bought the property, which is supposed to be a family compound for my retirement, future, whatnot, that we've saved and scraped and whatever and bought, we did not intend to have a neighborhood on the side of us. We are leaving a neighborhood to come to a rural area. All of the language speaks about existing residences. Well, we plan, I mean, it's zoned R2. I can put up multiple structures for my family on that piece of property, which I fully intend to do. And I called the city to ask for a plat of this development. Dan, I believe I spoke with, he didn't give me anything. He told me he would get back with me. I told him I had never been told about all of this, and he said, I'm going to find out. I'm going to find out about that. I never heard back from him. I showed up here thinking that this was not a decision-making night. My husband's not present. We never had the option to get legal counsel of our own to fight this. I do not want 150 homes on my dream property. I just don't. I mean, you can speak the nice language all you want, but if this was happening on your dream property, you wouldn't lay down for it. I mean, it's very upsetting that this is the first we're seeing. And I've read the city's comprehensive plan. I wasn't involved with the PUD and all that. I didn't own the property. But I can't see how that this PUD fits into the comprehensive plan with the road, with our supposed commitment to the ecological preservation. There's not much space like this left. The gopher tortoises, I mean, there's just tons of reasons not to put another planned unit development in the middle of beautiful Lake County. We have enough. I mean, and I feel like they're just being greedy. There is no reason to put 150 homes on, I mean, what is it, 120 acres? Where how many of those are already deemed wetlands? Conservation wraps the side of my property that comes up to it. There are cypress trees that are who knows how old. I don't understand how this is happening and how we weren't even notified that this was happening or given the information to, and I'm not saying everyone wasn't notified. I'm saying I was not notified. Under testimony, whatever, I was not notified.
Thank you, ma'am.
If you've ever been on that road, you do not want to have 150 more cars on it.
You know,
I don't think this tree needs to be disturbed.
are there any?
I don't think this.
Do we have any more questions for Mr. Spain?
Well, if I could just briefly respond to that, and this is what I was trying to avoid this evening. But again, if you look at the settlement agreement, nothing actually is getting finally approved this evening. You're approving a settlement agreement, which under paragraph 3 then provides, unless my client agrees to an extension, for 30 days from that effective date to approve the modified PUD, which 30 days from today would still fall within the April 22nd date. If the city were to fail to do that within the 30 days, or my client doesn't extend that 30 days, or the city were to decide that you're going to deny that modified PUD for one reason or another, paragraph 3 says this agreement shall be null and void and the parties shall retain all the rights to continue with the litigation, which is the pending circuit court proceeding that counsel alluded to, which under this agreement ultimately would get dismissed. All parties would bear their own fees and cost, and all parties do a mutual release as to any claims with respect to this matter. But again, the suggestion that something is being fully and finally approved this evening is not completely accurate. What you're approving is a settlement agreement by which you agree that you're going to implement the special magistrate's recommendation, which then requires a public hearing process, by which the first reading of that ordinance you did this evening as sort of an administrative matter. There's then a second and final reading by which the neighbors, just like any other zoning hearing, can come forth and try to present evidence to you all. They can try to convince you, I suppose, that somehow the special magistrate got it wrong after an all-day evidentiary hearing, even though they had every opportunity to speak at that hearing, and not one resident of those in attendance introduced any exhibits or spoke in opposition. So again, I will defer to you all. If you want to bump both these matters to April 22nd, I'm not going to object. But again, nothing is actually getting fully and finally approved this evening. This is simply a step in the process to get us to the second and final hearing.
How many commissioners have read the settlement agreement?
Everybody has read it.
Read multiple times.
And when did you receive it?
That would have been last Wednesday in the packet.
About a week ago. We've been briefed on it, but I did not read it till probably a week ago.
Right. When I asked you for one, we didn't have one available to us. Nobody said that it was going to be voted on tonight.
Comment?
If it doesn't get us in legal trouble, and if Mr. Spain is okay, it wouldn't, out of respect to the Sunnyside residents, I would look at it all on April 22nd. I'm a little confused, say we approve a settlement today. To me, we've approved a settlement. We're bound by it. I don't see a lot changing. But I mean, I'll throw that out for discussion. If other commissioners want to move it back, if you want to vote on it tonight, that's fine too. I'm not going to sit here and argue and debate it. I was involved in the original. Most of y'all were not here. I was here. I voted no, but I was here. Actually, it was Mayor when this came before us, and it's been a long ride.
Other comments with regard to putting it off till the 22nd? Is there any?
I don't see it.
No?
We'll defer to our legal And they're
So it does seem strange in that what Mr. Spain stated is that you have terms in this agreement that really make it null and void if you decide when you have a second reading not to approve. Even if you approve the settlement agreement tonight, the way Mr. Spain stated, the language in paragraph 3 says if you do not proceed or if you do not approve the PUD after the second reading, it's null and void and the litigation continues. So there's really no harm in proceeding, but ultimately it's up to you. Again, if you choose to re-advertise and have this at the same time you have the PUD, that's fine as well. He's agreed to that. So really, it's up to you.
I didn't see you sitting over there. I would have turned to you and asked. Sorry. It sounds like the final approval is on the 22nd anyway, but whatever the commission's pleasure is.
Yeah. So we do want to re-announce that the hearing will be at 5:30 p.m. April 22nd here at City Hall. Okay.
So yeah, just to clarify,
that's going to be the second reading.
The zoning and land use second reading and public hearing. Just the zone. Okay, the zoning hearing for the PUD for Sunnyside. Let me get the name right. Sunnyside Lake Land. Sunnyside Lake Landing Holding LLC will be conducted here at City Hall in the Commission chambers at 5:30 p.m. on Monday, April 22nd. Now that's the hearing on the PUD. Before this body is still the resolution to consider the settlement agreement.
So, in considering the settlement agreement, a suggestion has been made to put that off until the 22nd. And we need to decide, would we need a motion in order to do that?
No, you would need a motion to table until a date certain, which is what's been requested by Mr. Spain and which has been suggested by Mr. Cawthron. So a motion to table it to April 22nd would be appropriate.
There you go. So do we have a motion to table it?
The settlement
until
agreement.
April 22nd.
I'm looking at council, and if council says it doesn't create any legal liability for me, I would make the motion.
You can make the motion.
Okay, I would make the motion. We extend it to April 22nd and deal with the resolution and the second reading approval of the PUD at the same time.
Do we have a second? Lacking a second?
Lacking a second, the motion still stands to consider the settlement agreement this evening.
Right. Right. So we need to call a roll call.
Or unless you want to debate, or yeah, that's what he said.
Well, go ahead. We're going to decide tonight because we didn't get a second. Right. Okay. So this issue.
Right. So the motion to table failed.
Correct.
And now we're back to consideration of the resolution. I believe the resolution to settle the agreement had a motion and a second.
Yes.
So we're back into that process. So you can continue your debate, continue to take comments from the public.
No,
it did not have
an explanation. We didn't have a motion.
Okay, so we don't. So there's no motion on the floor.
Correct.
So you went right into public.
We let you explain it.
Yep,
right.
and then we went to public input.
So let's introduce. Would someone please introduce 61?
I'll introduce. It has to be read by title only.
Resolution of the City Commission of the City of Leesburg, Florida, accepting the settlement agreement with Sunnyside Lake Landing Holding LLC and Cenizo Ventures LLC and providing an effective date.
Move for approval.
Okay, discussion. I will say we have heard.
We need a second. We need a second.
We did.
No, we got it.
Okay.
Jay seconds?
Okay.
Yes.
All right. So we have heard from the Sunnyside property owners that they'd like to push this off until the 22nd. Mr. Spain has agreed that we can do that. Legal counsel said we can do that. We had a motion that did not get a second to do that. So our discussion on the issue of the resolutions between the commissioners. How you feel? Do we want to go on record or you just want to vote?
we can. I mean, because I was involved in the original one, it's been a tough process. I'm sensitive to the people that live nearby. I don't think it fits in the area. I voted no. I don't think it fits in the area. The density is too high. The roads are completely inadequate. But based on the process we've been through, doesn't leave me many options. It has not been a fun process.
Other comment?
No, I just wanted to.
Well, I do want to go on the record. I was completely against this project based solely on the fact, well, not solely, the roads are terrible, but every traffic study says they're fine, so we all know what that means. The city came to an agreement a long time ago, and the city said, we won't do this. And then the city did not implement that into our comprehensive plan. So when the petitioner purchased the property, they purchased the property under the assumption that they could do what they're suggesting they can do. Property owners have rights. We have fought this. We have lost. And it's a fact. And I cannot side with spending more of our taxpayers' money to fight something that we have lost. Although I know it's not the right thing in the world of right and wrong. We should have introduced this into our comprehensive plan. A lesson for everyone. We're redoing our comp plan right now. So it's a good idea for everybody in the room to be a part of those kind of things so you know what to expect. Because our comp plan says he can build what he wants to build, and it's in the city. We have no room. So,
and if I may add, that was way before our time. So I don't want people to think that that mistake was on our watch. It was 18 years ago. So I wasn't on the commission. No one was here. I don't want people to think we dropped the ball in the last year or two on this.
So as not to mislead the council, this may not eliminate attorney's fees that you're so concerned about.
I'm worried about taxpayers' money going for something that the special magistrate has told us we are not going to win. I am not an attorney. I rely on those attorneys to give me advice. And that's what the advice, I can read the recommendation to you into the record if you'd like to, if everybody'd like to hear it.
Mr. Mayor, I think we've had discussion and everything else. There's a motion on the floor. I think you call a roll call.
Yeah. Any other comments? Roll call.
Commissioner Reisman?
Yes.
Commissioner Peterson?
Yes.
Commissioner Berry?
Yes.
Commissioner Connell?
Yes.
Mayor Burry?
Yes. All right. We'll move on to item 7, informational reports. There are none. City attorney items.
Yes, sir, Mr. Mayor. Briefly, and maybe I'll give everybody a chance here. But as the commission knows, we're sort of in the midst of the transaction with the parcel across from the airport, the 10 acres or so. So we're kind of in the middle of the due diligence government approval portion of that.
Can we pause for a second?
Yeah, and I'll just hold on until everybody gets out. All right, so just as I was getting into, so the city's under contract with that parcel across from the airport right now, about 10 acres or so. The buyer is in the midst of their government approval due process period with that. They've sent us a couple of documents that need to be signed with the city still being the underlying property owner for things, permitting, FDOT, drainage connections, just some fairly mundane, fairly routine items, but I just wanted to bring that to the the commission's attention that I brought those documents this evening for the mayor to sign. Does anybody have any questions about where we stand with that transaction or anything relating to that? Okay. All right. Very good. That's all I've got this evening. Thank you all.
Thank you. City manager items?
I have no matters for you this evening.
Roll call.
Commissioner Berry?
Nothing at this time.
Commissioner Connell?
No, ma'am.
Commissioner Reisman?
Couple things. I want to give a huge thanks to the Special Events Department. I went out to the Balloons and Brews over the weekend. And that was a great time downtown. And then also Sergeant Shannon Walsh with the LPD and her team put on Roll with Patrol last night at Skate World. That was a fun time, even though I had an accident, but it's okay. Lastly, on April 6th is JAG, which is the Junior Athletic Games that the LPD puts on for all of our elementary students here in Leesburg. So I encourage you to come out to the high school and watch that. And then lastly, at the next meeting, could we get a Bike Fest update where we're at?
Yes.
Thank you. That'll be it for me. Thank you.
Commissioner Peterson?
Nothing tonight.
Mayor Murray?
Nothing tonight. Motion to adjourn?
So moved.
Second.
We're done.